Man sits in jail for over a year ready to go to trial. Then, on the eve of that trial, the prosecutor walks in and dismisses every single charge. Case over, right? Wrong. Days later, new charges, same dates, same evidence, and a defense attorney who says his client gave a year of his life while the other side figured things out. But the prosecution, they have a 1,600-page file, and what's inside it will stop you cold.
Court calls the case. People versus Stefan Scott. I said that.
Alexander, we have peaceful, Your Honor.
Here I go, see the hearing on behalf of the defendant.
Your name, sir?
Stefan Scott. Your Honor, at this point, I have received no discovery.
I don't think we have an appearance entered in our stuff. So I told Mr. Goldstein before made the appearance of momentary Wednesday.
Well, Your Honor, that may be true that they may not have a written appearance, but I have spoken to Ms. Tenhouse several times and asked her for discovery, and I have not received it. Nothing to do with Ms. Enda, but
Is there, well, but my understanding is it's sort of an automated process. Once it's sent in, the discovery's then sent out.
Last we had it sent, I believe, was to Mr. Killwall when he was originally on before Mr. Goldstein got back to,
if Mr. Killwall doesn't have it, I'll tell you, because I asked him for
He
it.
doesn't have it?
No.
I think we found a USB because there is over 1,600 pages of discovery, and then each of those is like separate police reports. I believe it's on a USB at our office.
Your Honor, I don't have a problem with an adjournment. I did file a green sheet, but I just want
No, I know. But I also want to make sure I don't get back here and then we don't. Because if Mr. Killowall didn't have it, if it's on a USB, that may be because he might not have picked it up. But I want to make sure that it's failing.
The problem is this case went from A to B to C to D. I'm the D. Mr. Killowall was either the B or the C. He kept switching to different people, which is one of the reasons why it took a while to get the substitution done, because we were always one step behind. But
Got it.
so if it's not entirely your office,
Because I still have, I have Mr. Goldstein now in the case.
Yeah.
Okay. So I guess I want to make sure the discovery is going to be available for pickup.
Yes, I believe Mr. Goldstein needs to bring a USB with him, and we can have it ready to copy over.
how big a USB? You know what? I've got an external drive that holds a lot. Yeah. Okay.
Okay, good. We got all the technical stuff worked out?
Yeah. Now comes the fun part, Your Honor, which is the issue of bond.
It might be fun for you.
If I can,
How long an adjournment did you want?
well, I'm going to be gone the month of June, so I'm talking about early July.
Okay. Can do July 2nd, is that right?
Hang on, let me check. I think that's good, but let me check. I'll make it work, Your Honor.
All right.
Now, on the,
Double cause conference will be adjourned. I'm trying to avoid.
I know you are.
That's basic.
You're doing a good job.
I know. All right.
All right, I'll try to make this as brief as possible. 14 months ago, my client was charged with some charges. Those charges were pending until about a month ago, when on the eve of trial, prosecutor's office nollie prost, and then turned around and filed the charges you have in front of you. None of them are new. All these dates go back to early 2025. So he basically sat in jail for a year. They then dismissed it and charged him with things they could have charged him over a year ago. Now we come to do the probable cause conference, and there's no discovery. Now, it's not their fault. I'm on vacation next month, but it's going to be another 4 or 5, 6 weeks before we can get back into this court and we can start moving forward. And none of this was at Mr. Scott's insistence. He was ready to go to trial all the way through. And the case kept sitting, and then they walk in and dismiss it. and well, I mean, I'm not going to argue the issue whether he's entitled to credit because that's not for you to decide. But one of the consequences of him sitting for a year was that nothing happened, and B, he could now lose the credit for that year.
But so that I'm,
Okay.
or from the people,
Go ahead.
so that I'm clear, the original charges that he was sitting, did he have an exam on that case?
I wasn't representing him at the time, Your Honor, so he did. Yes, he did.
So he had an exam, was bound over, waiting to get to trial, and then at the point of trial,
They nollie prost.
now they
And some of those charges that they nollie prost are included in the the complaint that's in front of you now. And then there are additional charges. But those additional charges could have been brought a year ago. And they chose to wait a year and not charge them. So at this point, Your Honor, I think it's only fair that he.
Well, but hold it.
Okay.
You're saying they could have been brought, so they didn't arise.
No.
Okay.
In fact,
Right.
if Bernstein is still here, he represented Mr. Scott at the time. They even argued some of those at the time of the bind over, but they were not added as charges. None of this is new. If you look at the dates in your complaint,
They argued it, they weren't added.
they tried to get in some testimony at the preliminary examination, some of the same information some of the same charges that are contained in the complaint that you have, and Judge Barr would not allow it. But they never moved to amend or bring those charges until April of 2026, a year later. So the case sat for a year, and those charges could have been brought either as an amendment to the information or as a separate case, and they didn't do it.
Let's be clear about what the defense is arguing, and it's a serious point. Stefan Scott sat in jail for over a year waiting for trial. Then, on the eve of that trial, charges were dismissed. Now he's back at square one with a new complaint, many of the same charges, plus more that the defense says could have been filed a year ago. Was this a delay, or was something much bigger quietly being built? The prosecution is about to answer that.
Response.
I did not handle that exam for the previous case. He was previously charged, I believe, with ag stalking. And at that exam, the victim did appear and testify. And after that exam, after speaking with her, it's my understanding that our office had Detective Pearson or Soering do a supplemental interview with her to go back over the entire history of their relationship and the domestic violence that occurred within that relationship for a potential new case that was submitted. That case was submitted, and that report was, I believe, 1,600 or so pages that Ms. Tanner had to review and go through and speak with the victim about before deciding what charges were going to be issued. And in that report, it does detail the 5.5-year relationship and numerous acts of domestic violence, including times that the victim was seriously physically assaulted to the point of having injuries and being assaulted while holding her child, thrown in a closet and choked. The child was taken to the hospital. There's other assaults that are detailed here that include her suffering extensive bruising, bleeding, difficulty walking, incidents of the defendant being at her house when police arrived, him telling her not to contact police and to tell them that everything is fine and have him come out after they leave, incidents of the defendant contacting her. Along with that, this extensive history points which the defendant was incarcerated on those previous cases that she did not appear for because of him intimidating or interfering with these cases. There was thousands of jail calls. I think at the end of that supplement report, what was submitted was a call log that included 1,004 completed calls during the pendency of those previous cases to the victim that were included in that report as well. So this is an extensive review of that entire domestic violence relationship, including potential for sex trafficking charges for this victim as well. I mean, it's just an extensive history of violence and aggression and abuse that this victim faced that we needed to sift through with her and the detective to get a full picture of what potential charges could even be.
That is not a simple case file. Over 1,600 pages, a 5.5-year relationship documented in full. Strangulation, assault while holding a child, thrown into a closet, extensive bruising, difficulty walking, intimidating the victim into telling police everything was fine, and 1,044 completed jail calls to the victim during the previous cases. The prosecution wasn't twiddling their thumbs. They were building a case that goes far deeper than the original stalking charge, including potential sex trafficking charges.
For this case.
Your Honor, it's a little unfair for her to give this litany of things for two reasons. One of which, this is neither the prelim nor a trial. And number two, I can't respond because I have not seen any of that material. So I think it's a little unfair for that to be brought up. You can see what the charges are. You've got the complaint in front of you. You can see the dates of the alleged offenses. And Ms. Enda has now indicated, yeah, they've had this information for a year now and did nothing. And it's just, so he basically was asked to give a year of his life while they twiddled their thumbs.
So, because that's not entirely true, Mr. Goldstein. I mean, at least the way that you make it seem, because he had a prelim and was bound over on the prelim. Now, as to what court scheduling or anything else along those lines, I can't speak to that. I mean, I get it that he's there, but then they come in and they dismiss the charges, but then they bring these back. I
mean, the only thing I disagree with what you just said, Your Honor, is they could have brought these charges a year ago. And now we're starting all over.
I mean, I hear what you're saying, but I don't know that. I don't know how ripe the charges were. I can't say that. Or whether or not they had all of the information. I mean, I hear what you're saying and that they requested that some of these be added, but.
Yeah, that's really as well from my review of our notes. What an extent of what this was discussed, but it was not the full extent of to sit down. I believe the interview was like 4 or 5 hours with this victim going over his history. We did not have that the day of the exam being up.
That's correct, Your Honor. But when was the interview? It was done within days of the exam. And they certainly knew some of this
after the exam. Which means he
some of it,
did not, right. I mean, okay.
Yeah, that's correct. That's correct.
Which means they couldn't have just added them because he would have been entitled to an exam on any added charges anyway.
Right. Any added charges. There's some information they already had, some information they got later. I can see that.
Let that settle in. Bond denied. The judge heard both sides, a defense arguing their client gave a year of his life while the case was built around him, and a prosecution presenting one of the most extensive domestic violence histories in recent memory. The judge acknowledged the timeline concerns but couldn't confirm the charges were ripe enough to have been brought earlier. With 1,600 pages of discovery still unreviewed by defense counsel, this case is far from over. July 2nd is the next battleground.
Well, okay. Anything else? At this point, I mean, certainly I would hear anything or get this thing set, but the discovery is now ready, given the adjourned date. At this point, however, I'm going to deny the motion for reduction in bond. His bond will continue as is. And certainly feel free to address it once you've looked at the discovery on July 2nd. Then. All right. Thank you.
Stefan Scott remains behind bars. His attorney picks up the discovery, 1,600 pages of alleged abuse spanning 5.5 years, and the next hearing is July 2nd. The question this case leaves: when does thorough investigation become an unfair delay for a defendant already sitting in jail? There are no easy answers. If this case had you thinking, hit that like button, drop your take in the comments, share it with someone, and subscribe for more courtroom breakdowns.